webinar today is on removing barriers to reentry, legal financial obligations, also known as LFOs. The webinar will offer you an overview of the barriers to reentry and the resources available, and an introduction to LFOs and an overview of relief criteria. The webinar audience is intended for professionals in the field who we define as case managers, advocates, and financial counselors, coaches to guide and contextualize the needs of your clients. I'm thrilled to have Nick Allen as our trainer today. Nick is an attorney with Columbia Legal and a subject matter expert on legal financial obligations. Thank you, Nick, for taking time to join us today, and welcome again, everyone.
Thanks, Alice. What we're going to do is go over some of the law around legal financial obligations in Washington State today. As Alice said, my name is Nick Allen. I'm an attorney with Columbia Legal Services. We're a statewide nonprofit civil legal aid organization with offices in 5 areas around the state. We work systemically on a number of issues that impact individuals that are in institutions around the state of Washington, as well as those who are returning from those institutions. And as part of our reentry and reintegration work over the last several years, one of those areas that we have focused on is legal financial obligations. So here's a little bit of a general overview of what we'll try to get around to today. First, talk about an introduction to legal financial obligations. We'll talk some about how they impact reentry. I'm sure a lot of the folks here on the call here are familiar with some of the ways that LFOs have impacted either themselves or their clients' reentry opportunities. We'll get into the laws around legal financial obligations in Washington, and then we'll also talk about what are some of the relief options that are available under the law for those who have LFOs. So just to get started, oftentimes the definition of legal financial obligations can be misconstrued or misstated. In Washington State, what we're talking about when we discuss LFOs can be different than what's discussed in other states or nationally. Oftentimes, this idea of municipal debt or legal financial obligations can all be lumped together to mean any type of court debt that is imposed on people. And in Washington State, we have a more narrow definition of legal financial obligations. And I've listed the statutory definition here from the Sentencing Reform Act. But what you need to know for purposes of this discussion is that we're talking about criminal court debts. So those are the debts that are imposed on an individual as a result of a criminal conviction. And they are imposed in all courts. So municipal courts impose legal financial obligations, as do district courts, as do superior courts, and they are imposed for all offenses. So you can receive legal financial obligations from the most basic of misdemeanors all the way up to the most serious of felonies. When we talk about legal financial obligations, we really want to, we can break them down into really 3 buckets of obligations. And those are fees, costs, assessments is the first one. The second one is fines. And the third one is restitution. And we'll talk about what each of these different types of obligations consist of. It's important in analyzing the type of legal financial obligations that you or your clients have for the purpose of getting a better grasp on what was imposed by the court, but also for what may be available for relief at the after they have been ordered and what type of relief is available. So here's a chart that kind of gives a brief overview of what each of these types of obligations is and their purpose. When you're talking about fees and costs, we can think of these as user fees or costs of recoupment. These are costs that are incurred by the state as part of prosecuting the defendant They're mostly discretionary, meaning that the court has the discretion on whether or not to impose them at the time of sentencing. Some common discretionary costs, one that often has come up is the cost for an individual's public defender. While that's discretionary, there, like most other costs, there is a mandatory legal financial obligation cost, and that is the DNA collection fee. I'll talk about how the law has changed around that over the last couple of years, to the point where now it is a one-time mandatory legal financial obligation. So for the first time the DNA collection fee has to be imposed, the court orders it, but now cannot impose it in subsequent convictions if it's already been imposed. Fines are for the purpose of punishment. So a conviction has occurred, and therefore the court can use that as a means to punish the defendant. Like fees and costs, most fines are discretionary, with one mandatory fine, and that is the victim penalty assessment. That's a mandatory $500 penalty that's imposed on folks who are convicted of any gross misdemeanor or felony in a state superior court, and it's $250 for any misdemeanor that's imposed in a state superior court. Restitution is imposed to compensate victims, to make them whole. And whether or not they are discretionary, whether or not restitution is discretionary depends on what court has imposed it. So in superior court for felony offenses, restitution is going to be mandatory. And wherever there is damage to or loss of property or injury to a person. In courts of limited jurisdiction, so municipal courts and district courts, restitution is not mandatory. It's discretionary. The court can choose whether or not to impose it. And I should also make a point here that the law does vary depending on whether or not it's in a superior court or a court of limited jurisdiction, and also can differ depending on where it's a felony or for a misdemeanor. I'll try to make those distinctions as we go along, but for the most part, assume that I'm discussing superior court felony legal financial obligations. Here's a overview of law changes that were made to some of the mandatory LFOs. So, I discussed the victim penalty assessment, the DNA collection fee, and here's how these have changed as a result of a law that was passed that we'll talk about here in a few minutes a few years ago. So the victim penalty assessment, prior law mandatory, current law is mandatory. You can't get out from under this legal financial obligation. And in fact, it was made stronger in this law that was passed a few years back, clarifying that it can't be waived, converted, or modified, and that all of the funds from the victim penalty assessment are allocated to victim programs. Next, there's the DNA collection fee. It used to be mandatory, like I explained, for every sentence that was imposed for a crime that was specified under the statute that's listed here. And like I also mentioned, now the court can only order the DNA collection fee one time. If they've already collected your DNA as a result of this statute, then they cannot impose it again. There's also the criminal filing fee that was mandatory prior to the change in the law. It's still a mandatory LFO, but there's conditions placed on that, and that condition being that it cannot be imposed if the individual is indigent at the time of sentencing. And the same applies to both the jury fee and the conviction fee that used to be mandatory. Cannot be imposed on people who are indigent. And I should note that the conviction fee is one of those LFOs that was a mandatory in courts of limited jurisdiction. $43 had to be imposed prior to the change in the law, and now cannot be imposed if the person is indigent at the time of sentencing. What I've found is that it's also helpful to know what are not LFOs, because oftentimes we will meet with individuals about LFOs, or they'll contact us and say, you know, I have speeding tickets, I have parking tickets. These are LFOs, right? And those are actually not legal financial obligations. There's a different set of laws that applies to civil infractions. Not that they can't be as devastating on the people who receive them, but they don't fall under legal financial obligation law. And similarly with the other two that are listed here, oftentimes we will get inquiries about consumer debts. Those are not legal financial obligations, and child support. But all of this is governed by a different set of laws and are not legal financial obligations. So moving along here, we'll talk a little bit just generally about the process and then get into what this looks like more specifically in a few slides. LFOs, though, what you need to know is that there's really three places where they can be imposed, ordered by the court. And that the first point is at sentencing. So after the person has received conviction, then the court at sentencing can order legal financial obligations be paid. The other two places where legal financial obligations can pop up, and it'll be important for our discussion later on about how to access information about legal financial obligations. One is at a restitution hearing, LFOs can be ordered, and then also following an unsuccessful appeal, legal financial obligations can be added to existing LFOs. And when it comes to payment, there's a monthly payment schedule that is usually set for an individual to pay towards their legal financial obligations. And that can either be set by the court, the clerk's office, or the collection agency if it's been turned over to collections. Collection also can occur in DOC if a person is earning money or receiving money. DOC will take deductions. And then it's important to know that after release, how LFOs are collected changes, opening up a whole new set of potential problems. Like I mentioned here earlier, funds while somebody is in the Department of Corrections, so while somebody is in prison, if they are receiving any wages for jobs in prison or monies from the outside, from say family and friends, those are going to be subject to mandatory deductions. And this is because DOC has a separate collection authority. And I noted the case here where the court clarified that that is the case. And I raise this because oftentimes what you'll see in court documents in a judgment and sentence is that the court will say payments to start, for instance, 30 days after somebody has been released from custody. And defendants will oftentimes be confused because there's that language in the court documents, but yet while they're in prison, DOC is continuing to take monies for their legal financial obligations. And this is why. It's because regardless of what the court has said, DOC has separate authority to collect, deduct from wages or monies that are put on the person's books for payment of legal financial obligations. And there's a whole host of other deductions that DOC is authorized to make. As you can see here, depending on the job or the type of money that is coming into the individual who's in prison, DOC has authority to take for, you know, legal financial obligations, crime victim compensation fund, child support, cost of incarceration. There's a whole number of deductions that DOC can take while a person is in prison, and can oftentimes leave them with, you know, little or nothing in their accounts as a result of that. And here's some of the deduction abbreviations for the different types of deductions that can be made. Legal financial obligations while in prison is generally a 20% deduction. So if I get you know, $100 from a family member, 20% off the top is going to be taken for any outstanding LFOs. The same can be said for work release. So individuals who are in work release or have clients in work release and are wondering why they're not getting the full amount of their wages for the work that they're doing. this is why. It's because there's a statute that's set up to deduct from earnings from work release. And what I've laid out here is the order of priority for how wages are deducted. So, the first thing is going to be reimbursement to DOC. Then you're going to go down to room and board, support for dependents, and then you get down to the 10% owed for legal financial obligations before monies can be deducted for payments to creditors or payment to an individual's personal account. So that's also something to keep in mind, is that if someone went in with legal financial obligations to prison and payments have been made and the person doesn't know why, it's because deductions were made from DOC. And similarly in work release, which is not only going to reduce the amount of money that someone ultimately receives from their wages, but also is going to should have some amount of reduction upon release from prison and then work release. So things change a little bit once a person is released from prison. And the main thing being is that mandatory deductions are going to end. Instead, for the vast majority of people, they're going to be making payment to clerk's offices in the county or counties where convictions have occurred. At sentencing, what happens is that the court can set the monthly payment schedule or can delegate that authority to DOC if the person is on supervision. If the person is not on supervision or is off supervision, then that authority is going to eventually be delegated to the clerk's office, and they are going to make the monthly payment schedule. One thing to keep in mind is that pursuant to a court decision by the Washington State Supreme Court, City of Richland versus Wakefield a few years back, the Washington Supreme Court said you cannot order a person to make payments if they're on Social Security disability. That doesn't mean that the court can't order the payment to be made, the sum. So they can say, I order you to, I'm going to order that you pay the victim penalty assessment. That's $500, but then cannot say, and you're going to make $30 a month payments if your sole source of income is Social Security disability. The other thing to keep in mind is that the clerk's office can require individuals to make annual reports, produce information to the clerk's office for purposes of making a payment schedule that is reflective of the person's ability to pay. And folks should not really fear getting notice from the clerk's office about this. Oftentimes, like in King County, they send out this letter to people who owe legal financial obligations that says you're required to appear at a administrative review. And people think that this is a court hearing, and it's not. What it is the clerk's office requesting information from the individual to see if there's been a change in financial circumstances for purposes of adjusting the payment schedule or keeping it the same. Folks should attend those administrative reviews or any request for information. One, because it is required under the law, and two, failure to report can result in the case being forwarded to the prosecutor's office for possible violations of the requirement to make payment on the LFOs. Courts of limited jurisdiction, things are a little bit different. Oftentimes, you're not making payments to the court or a clerk's office. In the vast majority of jurisdictions, they're going to contract with a third-party collection entity. And usually how this starts off is that you enter into you either pay off the amount in full to the court within like 30 days. If not, then you have the option of entering into a time payment agreement with this entity. Failure to make payments on with the time payment agreement can result in the account being turned over to collections, and can also result in possible sanctions as well. Now, time payment agreements are problematic because there's costs that come along with that. And I show an example here, and I know this is a dense screen, but it's not. It's going to put folks deeper into debt once they use the time payment example. And oftentimes there's no other choice because an individual cannot pay off that amount, in one lump sum or over the course of 30 days. So if you see here, on top of the amount that is owed, there is usually something along the lines of a setup fee. In the example that I give here from one of the local courts in Washington, a $15 setup fee. Then the monthly payment amount's not going to be based on a person's ability to pay. Rather, it's going to be based on the total amount outstanding. So here, if your account, the amount owed is under $1,000, then you're going to have to pay the greater of a 10% minimum of the account balance, or $25 a month. If the total is more than $1,000, then you're going to have to pay 5% of the account balance. So that can be problematic. Similarly, if the account is in current status, which means you're up to speed on your payments, there's going to be a surcharge on those amounts. And so, like it's listed here, $475 if you have one case. If you have multiple cases, that's going to bump up to $825 a month. And then if you're in past due status, you're going to be talking about an even higher amount to pay per month based on whether or not you have one or multiple cases. And there is the electronic payment fee as well. So all of these fees that add up can make it really difficult for somebody to pay these off in a timely manner, or for these to remain in current status. Eventually, a lot of these accounts end up in actual collections because an individual just cannot afford to pay according to the terms of the time payment agreement. And this fits into our next slide here, which talks about why LFOs are such a significant barrier to successful reintegration back into the community. So over the years, Washington has been highlighted in a number of reports as having a particularly flawed legal financial obligation system. And many of these reports have come out in the last 10 to 12 years. For the reasons that are listed here. It disproportionately burdens individuals who are living in poverty, and as a result, unnecessarily serve as a barrier to successful community reentry. Because oftentimes what we'll see is that a person has, completed all other conditions of sentence, doesn't have any new criminal convictions. The only thing that's outstanding is the legal financial obligations, and those can hang over an individual's head, as I'll explain later, oftentimes for the rest of an individual's life. So it all starts with poverty and the existence of the criminal record, plus all these other problems that have come up over the years. The existence of mandatory legal financial obligations, considerations of ability to pay, and that either not being done or that not being done adequately. Interest has always come up traditionally as a problem with legal financial obligations. And then, punishment for failure to pay, the fact that a lot of legal financial obligations, the court's jurisdiction to collect either does not expire or takes a long time before it expires. And then some of the things we've also talked about here already, which is, added fees and costs, particularly when an account is turned over to collections. Some of our really rigid restitution laws. And then there's always both direct, indirect collateral consequences that can flow from the existence of legal financial obligations. Fortunately, there have been some efforts to address some of the problems around LFOs in recent years. And probably the most significant change was the passage of House Bill 1783 during the 2018 legislative session. It's a comprehensive LFO bill that where advocates and impacted members of the community were involved in an effort to get this bill changed over the past several years. And what came out of that bill is laws addressing the interest rate, addressing mandatory LFOs. I've talked about that some earlier. Expanding opportunities for community service for some LFOs, creating more uniform standards around indigence, both at the time legal financial obligations are ordered by the court and when the state comes to collect. And then the final provision that was in this bill is really a victim restitution priority. Oftentimes, restitution that was ordered was not going first to victims. And so there was a provision in there that requires that any legal financial obligation payment must be prioritized for individuals and entities that are receiving restitution. So when we talk about the poverty issue, one thing to keep in mind is that folks coming through the court system are overwhelmingly indigent. For Washington State Superior Courts, there was a study done by the Office of Public Defense here in Washington, not too long ago, that said about 80 to 90% of people who are charged with criminal offenses in superior courts qualify for indigent defense. And indigence is defined under this statute, RCW 10-101-010. That's an important statute to know because it's sprinkled now throughout the LFO statutes, but basically means, your income is at or below 125% of the federal poverty guidelines, or you're receiving some kind of public assistance, or that you have been involuntarily committed to a state mental health facility. And there's a couple of other provisions that are in that statute as well. But we're talking about folks who have little to no income and can't meet their basic living needs, let alone legal financial obligations. While less is known about defendants in courts of limited jurisdiction, there just hasn't been a study along the same lines as for the superior courts. Anecdotally, there have been discussions with judges. There have been some surveying of judges through the LFO consortium that was pulled together in the last couple of years, where judges have said, that practice in courts of limited jurisdiction, that these are similar numbers, that the majority of people that are coming through their courts are also indigent. I'm not going to go too much into this because I think we've discussed it, but at sentencing, LFOs are going to be included in the judgment and sentence, particularly those that are, costs, fines, fees, assessments are going to be included in the JNS. The court is going to have to impose mandatory LFOs at that time. We talked about what some of those look like, and where you would want to find those is in the judgment and sentence. This document that lists the conviction and the conditions of sentence. And there'll be a page within the judgment and sentence that lists the legal financial obligations that were imposed at sentencing. Now, there are different types of LFOs, like I explained earlier, and even within some of those categories of LFOs, there's subcategories. And so you have a general discretionary legal financial obligation bucket. Those are, like I said earlier, LFOs that the court has the ability to waive at the time of sentencing. And then under that, you have discretionary costs. And costs, like is mentioned here in the slide, are expenses that are specially incurred by the state in prosecuting the defendant. And I mentioned some of the examples of what those look like. Costs of defense, so the cost for your public defender. Sometimes there are warrant costs. Sometimes there are extradition costs. There's a number of different costs that can be imposed by the court at the time of sentencing that would be considered discretionary costs. Now, before the court can impose these costs, it has to follow a specific process. And that is that it has to inquire on the record into the defendant's ability to pay. And if the person does not have the ability to pay, then the court cannot impose those costs at the time of sentencing. This is one of the changes in the law that occurred through that House Bill 1783. It used to be that generally at the time of sentencing, a court could impose discretionary costs at the time of sentencing if it found that the defendant had either the current or future ability to pay. And what that ended up, what ended up happening in those circumstances, people that were indigent at the time of sentencing would end up getting several thousands of dollars worth of LFOs because the court would say, you know, I think in the future you're going to have a job, or, you know, in the future you could come into some money. And so I'm going to impose these costs at the time of sentencing. Under the new law, the court cannot impose costs on a defendant who is indigent at the time of sentencing. And using that RCW 10-101-010, section 3A through C to make that determination. And I put some of the what that means underneath the indigent slide. Now, if the person is not indigent at the time of sentencing, then the court goes back to using that older law, the prior law. That means that the court has to consider the financial resources of the defendant and the burden that costs will impose. So if the person is not indigent, then the court can make a determination that costs will be imposed based on these two criteria. Now, unlike discretionary costs where the court cannot impose them if the person is indigent at the time of sentencing, that is not true for fines. Generally, there's no ability to pay requirement. Our courts have said that it is a best practice to consider a person's ability to pay before imposing fines, but there's no general requirement that it does so. That doesn't mean that there aren't some statutes that either allow for full or partial waiver depending on a person's ability to pay. There are certain fines out there. People that are convicted of certain drug offenses, there is a fine that says, you know, if you've been convicted of a drug offense, the court shall impose $1,000 fine if this is your first conviction, or a $2,000 fine if this is a subsequent drug conviction. But it also has language in there that says, unless this person is indigent at the time of sentencing. But for fines that don't have that language, the court doesn't have to do any analysis into consideration of ability to pay. But one thing to consider, there is one exception there, and that is if the person has a mental health condition. So the defendant can raise at the time of sentencing that they have a mental health condition, and there's a statute that requires the court to do an inquiry into ability to pay for everything but restitution and that $500 victim penalty assessment if they have a mental health condition. So this would be a way to still get certain fines waived if the person lacks the ability to pay, provided they have a mental health condition. It's a statute that oftentimes is overlooked at the time of sentencing. Now, for those individuals that have discretionary costs that were imposed by the court, they can seek remission or waiver of those costs. And there's a process for doing this. One, they can no longer be serving a term of total confinement on the conviction for which the LFOs were imposed. Second, they cannot be in contumacious default. I don't know why the legislature used that term, but it basically means that you just are not in willful noncompliance with payment of your legal financial obligations. And third, you have to show that you are that the costs create a manifest hardship for either you or your immediate family. Manifest hardship. Now we have a standard for that. That's RCW 10-101-010, section 3A through C. And you can also use General Rule 34, which has a standard of indigence that's in place. You file a motion with the court. In your motion, you have to show that you meet these three requirements. And then the court has the discretion to grant or deny that motion. It can also convert that those costs to community service at the state minimum wage is what you would get for each towards those costs, provided the jurisdiction has a community service program in place. we do a lot of remission motions, assist people with remission motions. Depending on the county, there can be really a lot of options for getting large amounts of legal financial obligations waived. I would recommend using this process if any costs have been imposed, because now with clarification in the law, courts don't have as much wiggle room for granting or denying these. And there's a lot of people prior to the change in the law that I mentioned earlier that have a whole bunch of costs that are eligible for relief. Just want to quickly go over where that new standard of indigence applies. So we talked about it in the discretionary cost context. It also applies with mandatory LFOs, with post-conviction sanctions. So when people don't have the ability to pay, talk about this a little later, there's also use that standard to show that you can't be sanctioned, and then also for setting of a payment schedule. So this indigent standard is everywhere. We talked a little bit about restitution and where and when it is required for felony offenses. Keep in mind, ability to pay is not a consideration. There was a Senate bill that was introduced this year. I think it was Senate Bill 6220, where it would have allowed for the court to have discretion where restitution was owed to a insurance company to waive or not impose the restitution. But I believe that bill has died. So it is an area where reform is needed, but this is the law right now that we have, at least for the foreseeable future. And I also talked about restitution can be imposed in a number of different areas at a number of different times. One is at sentencing, so the court can make a decision at sentencing that this is the amount of restitution that is owed and impose it in a order setting restitution, but also can do it within 180 days of sentencing if it does not impose restitution at sentencing. So if it doesn't impose it at sentencing, within 6 months, a restitution hearing needs to be held where that amount is entered or not entered. Restitution, if it's imposed at sentencing, you would want to look in the judgment and sentence. If not, it's going to be a separate order that's listed on a case docket that you would have to pull to say, oh, okay, this is the restitution that I have. This is how much I owe. The other way that legal financial obligations can be imposed after sentencing is if you have an unsuccessful appeal. So the court may impose appellate costs if an individual has an unsuccessful appeal. And we have what's known as rules of appellate procedure in Washington State that guide how these appellate costs are imposed. And the general rule is that costs, once a cost bill has been submitted by the state, must be awarded to the substantially prevailing party. So if I lose my appeal, I'm the state is the substantially prevailing party, and appellate costs have to be imposed on me. But there was a change to the rule of appellate procedure that says costs shall be awarded to the substantially prevailing party on review unless the person does not have current or future ability to pay. And what's also important about this is that it reiterates that the finding of indigence continues through the appeal. So this has been a big change in the law, and we've seen a significant reduction in the number of appellate costs that have been imposed on people who are unsuccessful on appeal and are indigent. But there's a lot of people who, prior to this change in rule, received those appellate costs, and they become a part of the trial court judgment and sentence and add it to any existing legal financial obligations. And these can be substantial amounts. They can range, anywhere from a couple of $100 all the way up to several $1,000s. The silver lining in this law, however, is that similar to general discretionary costs, you can also seek remission for discretionary costs. And there's the same, generally the same process that's outlined. Is you have to file that motion, show manifest hardship, that you've been released on the conviction giving rise to the legal financial obligations, and that you're not in contumacious default. And again, these are remission motions that are filed. You can file these at the same time if you have both general discretionary costs and appellate costs. You could address them all in one motion, and have been able to file and assist people with filing these, oftentimes with very positive results. We also talked about interest. Interest has changed significantly in Washington State. So it used to be that prior to the change in the law, interest accrued on legal financial obligations at 12% a year from the date of judgment on all LFOs. So that meant during the term of incarceration, people are seeing interest accrue. That means that if you can afford, $10 a payment a month towards your legal financial obligations, you still come out owing more the following month. The legislature changed the law so that interest is eliminated on all non-restitution legal financial obligations. So all costs, fees, fines, assessment, anything that is not restitution, interest no longer accrues. However, the law applies prospectively. So that means all that interest that accrued up until the effective date of the bill, which was June of 2018, remains in place. The good thing is there is an extra step people have to take, but it's a somewhat easy step. And that is filing a motion in the court or courts where the LFOs were imposed to get rid of that interest. And it's probably the easiest motion you can file in Washington State, because all you have to do is show that you have existing interest on legal financial obligations. And if so, the court has to waive that interest. There are some sample motions that are floating around on the court's website on WashingtonLawHelp.com. We have some sample motions. Sometimes counties will have other processes in place that allow for interest to, if someone pays off the principal, say on the legal financial obligations, they'll automatically get rid of the interest, or they will work with defendants to make this a much easier process. It would have been easy if the legislature would have just simply said interest eliminated both prospectively and retroactively. But this is the next best approach to this. Restitution interest was not addressed. So that continues to accrue at 12% a year from the date of judgment. And what's interesting is that even the relief from interest is difficult to obtain, because the only way you can get relief from interest on restitution is by paying off the principal in full. And oftentimes we see that restitution can be, $10,000, $20,000, $30,000. And so that's not a realistic option for a lot of people that owe restitution. Where it is a realistic option is where someone owes, say, $250 in restitution. At that point, the advice that should be given to them is don't pay off the restitution and not a penny more, because you should go back to the court and ask for a waiver of the interest on the restitution amount. It can save people a lot of money just by knowing that law. Next is failure to pay. So people can be punished for failing to pay legal financial obligations. That can result in arrest, incarceration, and if not arrest and incarceration, what a lot of counties will do is use wage and asset seizure, typically known as garnishment. Now, there's differences in the theories of how people arrive at that, depending on whether or not you're in a superior court or a court of limited jurisdiction. It's a condition of sentence in a superior court for felony conviction where LFOs were imposed. And if you are incarcerated, you don't get any credit towards your incarceration. That's different than if you're in a court of limited jurisdiction where it's a contempt of court theory. Jail time can be imposed, but you'll get credit towards those debts for every day that you serve. Doesn't mean that it's better. Doesn't mean that a person should say, oh, because I get credit, I'm going to go do jail time, because there are constitutional rights that are involved with this. You have a right to a hearing. You have a right to representation. And the court can't incarcerate you unless the failure to pay is willful. So what you need to do, or your clients need to do, if you're ever brought before the court for failing to pay legal financial obligations, is produce evidence that you you did not have the means to pay the legal financial obligations. And in that case, there are things that the court is required to do that does not involve incarceration. But what's important in these situations is the evidence factor. You cannot just plead poverty in general to the court and say, hey, court, I didn't have the ability to pay. You have to provide evidence. Usually that is done in the form of a financial declaration that's submitted to the court showing that you are indigent or otherwise lack the ability to pay the amounts that have been entered by the court. Now, that doesn't mean that this process works perfectly just because there's constitutional rights that are involved. Even if you get to the point where you can show that the payment was not willful, oftentimes we've seen around the state that folks are picked up on warrants for failure to pay and then incarcerated for 3, 4, 5 days, up to a week, awaiting a hearing to show the court that their payment is not willful. So it's not a perfect process. And there are ways to address that not occurring. It's not perfect either, but some of the things that you would want to do is check to see if there are any outstanding warrants. Keep your address up to date with the clerk's office and the court so that notice is going out, so that you're responding to the court with any notice around legal financial obligations. And again, this is not fail-proof because there are individuals, for instance, who are homeless, who can't provide that information under any circumstances, which can create problems. Here's the new law. I'm not going to go deep into this, but here are some of the process for failure to pay under the new law. And in italics is the things you want to pay attention to. Everything else was in place even prior to the change in the law. But if you're brought before the court for failing to pay, the court has to determine that the failure to pay was willful, and the court has to inquire into these things that are listed here: income and assets, basic living costs, your efforts to acquire the resources to pay. If the court finds you are indigent, you are presumed to lack the current ability to pay, and the court has to do certain things like has to either modify the terms of payment, reduce or waive the legal financial obligations, or convert to community restitution. If the person is not indigent but has no ability to pay, or it wasn't willful, the court can do one of those things. So there's a little bit more protection in the law, particularly for people who are indigent, that can open the door to a waiver of most legal financial obligations, except for VPA or restitution. Similar law applies if you're brought in for failure to pay for LFOs in courts of limited jurisdiction. It's just under a different statute. But you would always want to be able to provide information about your basic income, other legal financial obligations, your efforts to find the resources to pay. These are going to be the types of things you're going to need in order to show the court that punishment cannot be imposed. I talked about wage and asset seizure. So your wages can be garnished. There's also other mechanisms, order of payroll deduction, order to withhold and deliver, wage assignments, that all really work in the same way and can lead to significant amounts of a person's wages being deducted for legal financial obligations. They can take up to 25% of someone's disposable income, or as you see here, 35 times the federal hourly minimum wage, which leaves you with about $253 a week. In many instances, it actually is counterproductive because it discourages people from working if they know those large amounts are going to be taken out of their paycheck. But it's something to keep in mind. A lot of counties use this rather than arrest and incarceration. A lot of clerk's offices are reviewing ESD records and other databases to figure out whether or not somebody is making payment, has the ability to make payments. Again, another reason, if somebody's financial circumstances have changed and they can afford to make some payments, to contact the clerk's office and request a different payment amount that's going to the that they would make to the clerk's office, rather than having these mandatory deductions being made, which oftentimes are higher than the monthly payment amount would be. Let me see here. So, sorry about that. So another thing to keep in mind is that if you've got Superior Court felony LFOs, Superior Court jurisdiction does not expire until they are paid in full, with one exception. If you've got LFOs from an offense that was committed prior to June of 2000, then those LFOs are going to expire 10 years from the date of release from total confinement, or 10 years from the date of the judgment was entered, whichever is later. And the court can also enter an order extending jurisdiction for an additional 10 years. So that means if you have an offense that was committed prior to July of 2000, say you got out on July 1st of 2000, then those LFOs expire July 1st of 2010, unless the court entered an extension of jurisdiction, in which case you would no longer owe LFOs as of July 1st of 2020. We've been able to get a lot of relief from people who have older legal financial obligations this way. One, because either 10 years have passed, or two, because 20 years have passed in those situations where a jurisdiction has where an order extending jurisdiction was put in place. Courts of limited jurisdiction, that older law applies. Talked a little bit about collections and LFOs. You know, a lot of courts contract with collection agencies. They don't look at people's ability to pay. Added fees and surcharges are imposed, and rigid requirements. There's not a lot of flexibility in working with collection agencies. In those areas, in those places where there is both court collection and collection agencies, this is even more of a reason to stay in contact with the court so that those LFOs are not turned over to collections. Another thing to keep in mind is that if accounts are turned over to collections, one of the things you may want to do, if you have some ability to pay and not a lot of time has passed, is either write to the court, the presiding judge in some of the smaller jurisdictions, asking that account to be pulled out of collections, or in some of the larger jurisdictions, filing a motion with the court to ask that the account be pulled out of collections, because you're always going to be in a better circumstance if the payments are being made to the court. A lot of these problems here don't arise under that situation. We talked about relief from principal when it comes to remission. Here's some of the other options for relief. So I talked about at a show cause hearing, where you're brought before the court for failure to pay. The first thing you're going to want to do is show indigence. And then if you are shown to be indigent, the court has to do one of these four things, which can reduce the burden or totally reduce the burden of legal financial obligations. Also keep in mind that a court can suspend a fine at any time. And so, you know, yes, the payment still could be hanging over a person's head if they don't meet certain conditions. But if they do, those fines can go away. So you always have the option of going to the court and saying, if I have a fine, court, will you suspend this fine? Because I don't have the ability to pay. Restitution is different. Like I mentioned, for felonies, you're not going to have any opportunity to get rid of that restitution until the principal is paid in full. Courts of limited jurisdiction, you could request that the court adjust your restitution amount. Here are some of the things that I like to think about when accessing relief. You want to figure out what court ordered the LFOs and do you have proper documentation. And then you want to ask what relief is being sought. I list out some of the four things here. That is usually the universe of relief available or that our people are seeking with LFOs. Getting rid of interest, waiving the principal, avoiding punishment for failure to pay, and removing accounts from collections. And then as more time goes on, there will be fewer requests also for getting rid of expired legal financial obligations. But this is really what your universe of relief is going to look like. Some of the other questions that you want to ask are, where are these legal financial obligations from? What counties, what cities, what courts are they in? because there's a lot of disparities. There's not a lot of uniformity with legal financial obligations. We do not have a unified court system in Washington State. And so you really have 39 separate counties that have 39 separate practices around legal financial obligations. Knowing where those LFOs are imposed can have a big impact on whether you can get relief and how that relief will be granted. Here's some resources that you would want to use to start getting initial information about legal financial obligations, to look at the docket to see what documents you need to pull. And then once you see what documents you need to pull, you can start going into some of the online databases for court records to pull the actual documents. And you can also go in person to clerk's offices to pull those documents in person. There's going to be a cost involved with all of this, but this is how you would start getting a handle on your legal financial obligations. I'm going to skip past this one because it's not the best, most clear document. But here's what you want to be looking for generally: the judgment and sentence, any order setting restitution, any LFO related correspondence that's come from the court or a collection agency, any orders extending jurisdiction. The other document that you'd want to get your hand on if you're looking for relief is case financial histories. Each court has an accounting of legal financial obligations and the amounts that have been paid and what has been imposed. So you can see how much in costs, fines, restitution, as well as how much has gone towards those obligations. And then you'd also want to get any billing statements that have come from the court. You can skip past these. These are just examples. I want to wrap up here because I know we only have a few minutes left. One of the things that's out there is LFOs and voting. Keep in mind that the old law used to be that you did not have the right to vote if you had a felony conviction and then your legal financial obligations were not paid. That right now under the law is provisionally restored once you are no longer under DOC supervision. There's been some bills that have been introduced by the legislature. Unfortunately, none of those have been successful to this point. So this is the current law. You could have that right revoked if you fail to pay legal financial obligations, but that has not happened as far as I know, and in discussions with others about the law on that. So that wraps us up. I know we have about 2 minutes left here. I'd be happy to answer any questions right now, or I think in talking with Alice, you could forward questions to her. She'll get those to me, and I'd be happy to respond to each one of those and get back to you individually. That is everything that I have, and here's my contact information.
So Nick, thank you so very much, and thank you everyone for attending today. I do have a few questions, and so this ends our formal webinar, but I'm going to go ahead and read to Nick some of the questions. If you have questions that we aren't able to answer today, please feel free to send them to me at Coday, C-O-D-A-Y, at everyoneiswelcome.org, and we'll put together a Q&A. The PowerPoint will be made available as well as the recorded webinar. So the first question I have here is there a way for someone to, well, no, can people that violate for failure of payments be incarcerated for being poor in the state of Washington?
Well, the way I explained it is how it's happening now. It used to be a more common practice that people were being picked up for failure to pay, going before the court. The court was finding willfulness because they weren't doing an inquiry into ability to pay or an inadequate inquiry, and people who were indigent were doing time in the county jail for failure to pay. That isn't happening as often in Washington State, and technically it should not be happening because that's a constitutional violation. What has been happening now is that you get picked up on a warrant for failure to appear to discuss non-payment of legal financial obligations, sit in jail for 4 or 5 days, go before the court, and the court finds that it was non-willful. Is either situation better? No. In both cases, people are doing what can add up to significant time in jail. So the answer to the question is yes, it occurs. From my information, the information I have, it's less so than before the changes in the law, but it's kind of in some jurisdictions changed how people are incarcerated. In both instances, that should not be happening.
So Nick, I have one more, and I think they wanted you to elaborate more on community service.
Yes. So community service, it's not widespread. There are some options, for instance, for some motor vehicle related convictions where you can convert certain legal financial obligations to community service. Similarly, if you are brought before the court for failure to pay, there is the option of the court converting some of those legal financial obligations, particularly things that are not the victim penalty assessment or restitution, to what's known as community restitution, which is community service, provided that jurisdiction has a operating community service program. The other way that you could get it converted to community service is through that remission process. So you show the court that manifest hardship has been met, you've been released from the term of total confinement, you're not in contumacious default. The court could either waive those discretionary costs or could convert to community service, again, provided that there's a community service program in that jurisdiction. Outside of that, you would have to look to the statute for the conviction that was imposed to see if there is the option for conversion to community service. Usually there's going to be more options in courts of limited jurisdiction for community service. Again, provided they have those options in place, a program in place. For felony convictions where LFOs have been imposed, the options that I gave are pretty much going to be the scope of what is available.
So thank you, Nick. I also want to say thank you to everyone for attending. Again, the recorded webinar will be made available to all those who registered, as well as the PowerPoint. If you have questions, please feel free to email me directly and I will send them to Nick, and we'll put together a Q&A of everybody's questions and then his response. So this ends our webinar for today, and thank you so much for attending. Have a great day.
Thank you.